Good morning, everyone. So please pardon any outside noises that you may hear. And let's continue with Title 11 or Non-Stock Corporations. So Section 86 talks about the definition of non-stock corporations. And Section 87 here talks about its purposes. So let me just give a few things to note when it comes to the introduction to non-stock corporations. One, if you look at Section 86, one of the important parts, if not the most important part, is that it must not distribute any part of its income as dividends to its members. So the requirement that there shall be no distribution of income does not only refer to distribution in terms of cash, but can also be in terms of property. There is a Supreme Court ruling because if you look at the definition, there are particular requirements. No part of its income is distributed, and that it can actually earn income as long as it is incidental to its operations. Also, that there are particular purposes for which it may be formed under Section 87. So, you will notice that there is no particular statement that the that there should not be any capital stock. And this was actually clarified in a Supreme Court case where the SC said that even if there is capital stock, as long as the dividends are not there are no dividends declared and nothing is distributed to the members, then it is still considered a non-stock corporation. So a corporation, if you look at the definition again, necessarily shows that it cannot be a non-stock if it does not have members. And because there is already a separate law on the cooperative organized through the Cooperative Development Authority, a non-stock corporation cannot be a cooperative. So here is the table. For easier reference, I have taken a picture from the book I am using of Aquino and Aquino on the distinctions between a stock and a non-stock corporation. There are actually 16. So this is the first page. Just take a screenshot of this. And this is the second page. This is for easier reference so that I don't need to discuss this one by one. When you hear the word non-profit, it's just to describe that the corporation does not distribute any part of its income to stockholders or members. So when you say non-profit, it does not mean charitable. Just take note of that. If you cross-refer sections 86 and 87 to section 13I of the Revised Corporation Code, where the non-stock must state the amount of its capital, the names, nationalities, and residences of its contributors, and the amount contributed by each, the capital involved is to be used for the operation of the corporation. So it may be increased because the members are always free to give additional contributions, in which case there is no need to amend the non-stock corporation's articles of incorporation. Now, there may be some corporations that are governed by nationality laws and that can be incorporated as a non-stock corporation. In those cases, the nationality of the non-stock corporation is computed on the basis of the nationality of its members and not on the contribution, unlike in stock corporations where you look at the outstanding capital stock. Diba? So, in stock corporations, it's possible that one foreigner is just one amongst, say, 100 stockholders, but because that foreigner owns more than 40% ownership, then that corporation will be considered a foreign owned. So when you talk about, so in relation to the nationalized activity, a non-stock corporation which was organized to undertake social, cultural, educational, non-profit activities cannot be read in the context of the term partly nationalized activities. What it means is that just because a non-stock corporation is engaging in social, cultural, educational, non-profit activities, then it is a partly nationalized activity because it's in furtherance of, say, state policies. Um, Therefore, social, cultural, educational nonprofit organizations can be owned by foreign nationals then. When you talk about partly nationalized activities or nationalized activities, these are activities that are clearly stated under the Constitution or the laws that can be held only by domestic corporations or Filipino nationals. I'm just saying that because you might confuse it thinking na okay, it's for charitable purposes, it's for social purposes, then because it will benefit say the the country, then it's a nationalized activity. That's not true. So what about for recreational purposes? If you look at section 87, there's no such thing as recreational here. What about sports clubs? Well, sports clubs are primarily meant for income generation. So they cannot be used as they cannot be formed as a non-stock corporation. However, if the sports club is organized for fraternal purposes, then it enters section 87. It can be organized as a non-stock corporation. So, as a general rule, a non-stock corporation is not empowered to venture in profitable business. As an exception, it is allowed if it is just in that if the profit is incidental to its operations and will be used in furtherance of the purpose for which it was organized. The fact that a non-profit corporation earns a profit does not make it a profit-making corporation. I hope that makes sense. So, because of this provision, the second part of the first paragraph of Section 86, a non-stock corporation therefore may invest its funds in order to earn additional income for paying for its operating expenses and meeting benefit claims. So that's allowed. So as I've mentioned in one of my earlier videos, say a non-stock corporation can operate a restaurant to cater to its members if the revenues from that business will be used to defray overhead expenses of the corporation. So, for example, for religious corporations, a non-stock non-profit corporation for religious purposes non-stock non-profit corporation for religious purposes can engage in the retail of its paraphernalia like Bibles, and that's allowed. But it cannot run a franchise. Why? Because a franchise is really a business system that is operated for a profit. For those of you, I'm sure you all know, franchising is an arrangement where the franchisor grants the franchisee the right to use its trademark or trade name and to use its business systems in exchange for a fee plus percentage of sales. So by that definition already, you cannot say that franchising is only incidental to its operations. Okay? Because if franchising again by itself is for income generation talaga, not as an incident. It's a primary purpose. So again, I will repeat, in terms of distribution of income, I mentioned earlier, does not just limit itself to distribution of cash or property. It can actually be in the form of receiving benefits like commissary privileges, importation of goods duty-free, purchase of food and other items at reduced prices, or return or refund of capital at the end of the membership. So these are forms of distribution of income that is not allowed under Section 86. How about conversion? Let's just move ahead a bit. A non-stock non-profit corporation cannot be converted to a stock corporation because the amendment would be inconsistent with its nature under Sections 86 and 87. So what would need to be done if a non-stock corporation wants to be converted to a stock? First, it must dissolve and then it must incorporate into a stock. So it cannot be by mere amendment. Continuing on to the members of the non-stock corporation, Section 88 provides for the right to vote. What needs to be noted in this section is that the right can actually be limited, broadened, or denied, which is not available when it comes to stock corporation. So this is one of the differences. As long as it is actually stated in the articles or the bylaws, does not need to be on both. So there may be a formula, for example, in the articles or in the bylaws, where the vote is based on the amount of contribution of each member, and that's completely fine. There may also be instances where a non-stock corporation may prohibit proxy voting in any meeting. But in the absence of any statement to the contrary, when you're talking about quorum, you are talking about actual members and not amounts of contribution. And instead of a stock and transfer book, their basis would be the membership book. What about delinquency? The rules on delinquency also apply to non-stock corporations. Disenfranchisement due to delinquency results in that delinquent member from not being included in the determination of quorum. So, similar to restricting voting rights, the bylaws may also provide that the quorum may be less or more than a majority of its members. And this is the continuation of Section 88. So similar also to non-stock corporations, the bylaws may provide for voting through remote communication or in absentia. Section 99, non-transferability of membership. They are personal and non-transferable, but that is just a general rule. It can be allowed if, again, it's stated in the articles or in the bylaws. So why is it generally non-transferable? Because there are personal elements in non-stock corporations that require a qualification by social or other ties. So usually most non-stock corporations are for memberships, clubs, ganyan. So normally they would want some sort of sabihin natin exclusivity. For what if it becomes transferable because of a provision under the articles of bylaws? Because such as is an exception, a transfer will only be valid if the terms and conditions stated in the articles or in the bylaws are strictly complied with. So what do you mean when you talk about transfer? It includes all transactions where the property of one person becomes the property of another. So it includes transfers by inheritance. What does it mean? The heirs of a deceased member will not acquire membership unless the articles or bylaws provide for such transfer. What about termination of membership? So it is in the manner and for causes stated in the articles or bylaws, and the effect is that it will distinguish all the rights of the member unless there is a provision that states that not all the rights are extinguished, and these will also be found in the articles or bylaws. When we're talking about termination, it would be best to talk about it in relation to admission of members. So while the power to admit members pertains to the board, in the absence of any contrary provision in the articles and the bylaws, then the power to terminate is also normally vested with the board. So, while a non-stock corporation cannot be compelled to accept any person as a member, please note that the person who desires to be a member can still sue the directors who unjustly or unfairly refuse to accept them. And this would be covered under sections 19, 20, 21 of the Civil Code. And that talks about abuse of right. So what about suspension? So it's in the middle of, it's not exactly a termination. The bylaws and the articles can still provide for suspension. And a member who is validly suspended cannot complain and sue for damages if it was done in accordance with bylaws and if it's with sufficient evidence. So there, for those of you who are familiar with non-stock corporations, as I'm sure you have parents or you yourselves are members of certain clubs, you will notice that there are times where membership involves property rights, like the purchase of shares is a condition to membership. So in that case, loss of membership following Section 90 also entails the loss of those proprietary rights. What do I mean by proprietary rights? Usually, these are instances where there are so-called proprietary shares. These are actually, the reason why I put it in quote is because there's a particular definition for proprietary shares or certificate under the implementing rules of the Securities Regulation Code. where it states that a proprietary share as an evidence or interest or participation or privilege in a corporation which gives the holder of the share or the certificate the right to use the facilities covered by such certificate and to receive dividends or earnings from the corporation. So that is for stock. But there are also non-proprietary shares where there is a right or privilege given to the holder, but only limited to the use of specific property. So as I mentioned, for those of you who are members of clubs, you will notice that the purchase of non-proprietary shares is included, where the member will be allowed to use the facilities. So even if there are shares in that sense, the corporation is still non-stock. So a non-pay, what is an example of a ground that's usually stated in the articles or in the bylaws? Non-payment of dues, because a non-stock corporation may collect because it's necessary to accomplish its purpose. Of course, it's not a profit organization. Therefore, where the question would be, where would it get its money to defray expenses? Normally from the members themselves. So while the non-payment of dues can be a ground for termination of or suspension of membership, again, the procedure in terminating or suspending a member must strictly comply with the procedure stated in the bylaws. Let me just clarify. While the and you should know this, the approval of the commission is not necessary to collect dues. Therefore, the dues may be collected even if it is not clearly stated in the provisions of the bylaws. The termination or suspension because of non-payment must comply with any provision stated in the bylaws, therefore. Because there's a difference between collecting and suspending because of non-payment. In non-stock corporations where the purchase of shares is a condition to membership, the articles or bylaws may provide that unpaid dues shall constitute a lien on the member's share. What does it mean? That non-payment, parang your membership will be a collateral to any condition for, syempre, membership dues are usually annual, diba? So in cases where the member fails to pay membership dues and the shares of the member is alien on the membership dues, then any delinquency, so to speak, is not covered by Section 67 on delinquency sale. Bakit? When you talk about delinquency sale under Section 67, there is delinquency because the stockholder failed to pay the subscription price for the shares. Whereas, constituting alien over members' shares is because of failure to pay dues, and meaning the shares have already been fully paid. And that's the reason why if ever a non-stock corporation decides to hold as security the shares of the member in case the member fails to pay membership dues, the non-stock corporation or the member cannot require compliance with Section 67 of the Revised Corporation Code. Just note that when you talk about membership, usually there must be notice and a fair opportunity to be heard for due process. Kawawa naman the member if you just terminate him outright. Although if it says there that membership will be automatically terminated, it's not exactly disallowed as long as it's in the articles and the bylaws, because members are expected to know and are presumed to have notice of the contents of the articles. So what about death of the member? The determination of whether or not dead members are entitled to exercise their voting rights through their executor or administrator depends again on the articles or bylaws. So you notice when it comes to non-stock corporations, there is great emphasis on the articles and the bylaws. Moving on to Chapter 2, Trustees and Officers. The election in term of trustees, the number the number shall be fixed in the articles, which may or may not be more than 15, meaning can be any number. Excuse me. Note, the reason why I highlighted number is because the term need not be stated in the articles. So what is required is that they shall not hold office for more than 3 years. Therefore, a non-stock corporation whose articles or bylaws state that the term of the trustees shall exceed 3 years is void. So all members of the board of trustees must be members of the corporation except independent trustees of non-stock corporations vested with public interest. So what are corporations vested with public interest? Please refer to section 22. And in cases like this, members may directly elect officers of a non-stock corporation as compared to a stock corporation where it is the board that does that. What about the list of members? It shall be updated 20 days prior to any scheduled election stated here. And what is unique is that the bylaws may provide that the meetings may be outside the place where the principal office is. This is different from a stock corporation. Also, note that there must be proper notice. So the only limitation as to where the meeting shall be held is that it should be in the Philippines. So it can be in Amanpulo, diba? Or in Coron. Note that section 92, any liabilities, say for example, failure to give proper notice, can subject the person or persons responsible to section 161. So why can the number of trustees be more than 15 unlike in stock corporations? This is to give more representation, especially if a non-stock corporation involves nationwide membership. So when you couple it with the right to limit members' right to vote, it can be possible that say members of a non-stock corporation can only vote for officers who will be assigned in Luzon. It cannot be those in Visayas or Mindanao. That's allowed. Although there is this right to limit or expand voting rights of members and that there is now an unlimited number of trustees, it should be noted that the number of trustees should never exceed the number of members. As a side note, the SEC has adopted a policy of requiring non-stock corporations to submit an explanation as to why there is a need to have more than 15 members of the board. Because the SEC can actually check if it feels that, say 20 is unreasonable considering that the non-stock corporation is just of a particular size. When we talk about distribution of assets in non-stock corporations, these are governed by sections 93 and 94. The assets of the non-stock corporation undergoing dissolution for reasons other than those set forth in section 139 shall be governed by letters A to E. So these are the process or procedure that must be followed. Just note that under letter D, assets other than those mentioned in A to C, if there are any left, shall be distributed in accordance with the provisions of the articles or bylaws to the extent that the articles or bylaws determine the distributive rights of members. So distribution of assets to members upon dissolution is allowed only if it is expressly provided for in the articles or bylaws. In the absence of any provision in the articles or bylaws, the assets may be distributed in accordance with the plan of distribution to persons, societies, organizations, or corporations, whether or not organized for profit as specified in the plan. So just read the rest of the provisions when it comes to section 94 because they are relatively self-explanatory. So this is the plan that I just mentioned, the plan of the distribution of assets. So that ends Title 11. And I will see you in Title 12.